Hi, my name is Jessie, and I'm a student at the Indigenous Community Legal Clinic, also known as the ICLC, in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Solo nations. This video is part of the Lived Law series on housing. In this video, we're going to discuss how to know if the Residential Tenancy Act applies to your housing situation. Why is it important to know this? The Residential Tenancy Act, also known as the RTA, is a piece of tenant protection legislation that outlines the rights and responsibilities of both tenants and landlords. It gives tenants a number of rights in relation to their landlord. For example, protections against eviction and restrictions on rent increases. It also allows tenants to bring their housing disputes to the Residential Tenancy Branch, also known as the RTB. If your housing situation does not fall under the RTA, you still have certain rights under what's called the common law, but your rights are not as clear and cannot be enforced through the RTB. Landlords are not obligated to inform you of your rights under the RTA and may not be familiar with the RTA themselves. Also, in some cases, they have an incentive not to inform you of your rights or to claim that the RTA does not apply to your housing situation. This means that it is important to judge for yourself whether the RTA applies to your situation. While there are some types of housing that are excluded from the RTA, most rental housing in the province does fall under the Act, and you should not take your landlord's word for it if they tell you that the RTA does not apply to you. So, what does the RTA apply to? The Residential Tenancy Act states that it applies to three things. First, tenancy agreements. Second, rental units. And third, other residential property. This means that, subject to a few exceptions that I'll get into in a moment, the Residential Tenancy Act applies to all rental housing and any agreement between a tenant and a landlord that has to do with possession of a rental unit or use of common areas in a building. It even applies to agreements that aren't written down. If you have a verbal or implied agreement with your landlord, you are still protected under the RTA. What housing situations are not covered by the RTA? As previously mentioned, there are a few housing situations that are excluded from the protections of the RTA. These exclusions are not as broad as you might have been told. For example, there is a common misconception that all nonprofit housing is excluded from the RTA. This is not true. Only certain types of nonprofit housing are excluded from the RTA. So what specific housing situations are excluded from the Act? First, not-for-profit cooperative housing. But this exclusion only applies if you are a member of the housing cooperative. If you are renting from a member but are not a member yourself, the RTA still applies to you. Second, living accommodation owned or operated by an educational institution, such as a university. Similarly, this exclusion only applies if you are a student or employee of the school. If you are neither of those things, the RTA still applies. Third, living accommodation in which the tenant shares a bathroom or kitchen facilities with the owner. Note that, for this exclusion to apply, you have to share a bathroom or kitchen with the actual owner of the property where you are living. If your landlord claims that this exclusion applies to your situation, you should confirm that the person you're sharing facilities with is actually the listed owner, and not just someone who is leasing or using the property. You can look this up by doing a land title search in the Land Title Office. Fourth, living accommodation occupied as vacation or travel accommodation. This does not exclude all hotel accommodation from the RTA. Hotel accommodation still falls under the RTA if you have some form of tenancy agreement, including a verbal agreement, and the property is your primary or permanent home. The fifth exclusion is living accommodation provided for emergency shelter or transitional housing. For transitional housing to be excluded from the RTA, it has to meet three strict criteria. First, it must be provided on a temporary basis. Second, the person or organization providing the housing must receive funding from the local or provincial government to provide the accommodation. And third, it must include programs intended to assist tenants to become better able to live independently, meaning they must have at least a general plan as to how tenants will transition to more permanent accommodation. If your housing situation does not meet one of these criteria, for example, if your housing is provided on a long-term basis and there is no plan in place to transition you to a more permanent accommodation, the RTA still applies to you, even if you have signed a so-called transitional housing agreement or program agreement. The sixth exception is housing that falls under the Community Care and Assisted Living Act, the Continuing Care Act, the Hospital Act, or the Mental Health Act. The seventh exception is housing in a health facility that provides hospitality services and personal health care, or that is made available in the course of providing rehabilitative or therapeutic treatment or services. For this exclusion to apply, your housing must be located in a healthcare facility and must provide both hospitality services and personal health care. If your housing does not meet all of these criteria, for example, if it provides hospitality services but not personal health care, it does not fall into this exception, and the RTA still applies. The eighth exception is housing in a correctional institution. The ninth is housing that falls under the Manufactured Home Park Tenancy Act, or MHPTA. The MHPTA is a separate piece of legislation that mirrors the RTA and applies to tenancies in mobile and manufactured home parks. Note that if your housing falls under the MHPTA, you can still bring your housing disputes to the RTB. It's just that your rights and responsibilities are set out in a different act. And finally, the 10th exception is most rental housing on reserve. This exception applies unless the landlord is not a First Nations person or banned government, and the dispute is not about use or possession. There are a few other exceptions that are less likely to come up, such as tenancy agreements with terms longer than 20 years. But otherwise, if your living situation is not one of the specific ones mentioned, the RTA applies to you. What is not excluded under the RTA? Before moving on, I want to talk about a few housing situations that people often think the RTA doesn't apply to, but are actually covered by the RTA. The first is subsidized housing, including public housing, nonprofit housing that is not part of a cooperative, and housing for which you may have received a rental supplement, such as through the Rental Assistance Program. Just because you're not paying market rate for your housing does not make it exempt from the RTA. Second, supportive housing. While transitional housing is not covered by the RTA does apply to long-term or permanent living accommodation for individuals who need support services to live independently. This would include a lot of the housing provided by organizations such as Rain City Housing and Atira. Finally, single-room occupancies. Single-room occupancies, or SROs, refer to one-room rental units that are sometimes located in residential hotels. If you rent an SRO and it is your primary or permanent residence and not a vacation accommodation, you are likely covered by the RTA. To recap this section, the big takeaway from this section is that you should not assume your housing situation is excluded from the protections provided by the RTA, even if your landlord or housing provider claims it is. While there are certain housing situations that are excluded from the RTA, as you have seen, those exclusions are quite narrow, and many common types of low-income housing are included under the RTA, including supportive housing and single-room occupancies. Additionally, even if your housing situation appears to fall within one of the excluded categories, it may not actually meet the strict criteria to be excluded. For example, if you have signed a transitional housing agreement, but your accommodation is long-term and there is no plan to transition you to more permanent housing, your housing may fall under the RTA. Finally, if you are not sure whether your housing situation falls under the RTA, it is always a good idea to file an application with the RTB or speak to an advocate to get an answer on this. And the reason why all this matters is that the RTA gives you really important rights and protections as a tenant, which I will discuss in more detail in the next section. To access that section, watch the video Part 2, Rights under the RTA.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.